Well, good morning, everybody. Thank you for joining today. I am Tony Russo with CINJ. I think I know most of you on the call, but today's seminar, we're going to spend the next hour talking about Daniel's Law and the implications and the impact to businesses. And we're fortunate to have two speakers here, John Molinelli, who is a former Bergen County prosecutor. He's also a partner at Price, Meese, Suleman, and D'Arminio. And joining John today is Kelly Percaro, who is an attorney with Greenspoon and Martyr in Newark. And just to give you some background, and then I'll turn it over to John and Kelly. Back in 2020, unfortunately, Judge Esther Salas's son, Daniel, was murdered after a disgruntled person found her address, went to her house, shot her son and husband. And then about 4 months after that unfortunate situation, the New Jersey legislature enacted Daniel's Law, which is all good intended to protect covered persons from public disclosure of their address and information. So that since 2020 and 2023, the law was amended again. And that's really what we're going to focus on today is the amendments in 2023 and what it means to business and the impact to businesses if you have information related to covered persons. So with that, I'm going to turn it over to John, who will give a little bit more background on Daniel's Law, and then we're going to ask Kelly to talk about the 2023 amendment. So welcome, John and Kelly.
Thank you, Tony. Whenever I speak on this topic, I always start with Judge Salas. We all need to remember just how horrific that incident was. But what a lot of people may not know is her efforts, the work that she put in to seeing to the passage of Daniel's Law. It is named after her son. She worked tirelessly, made public appearances, and spoke vigorously to New Jersey governor, legislators, the public about the need for a law that would protect the dissemination of her personal information. The person that committed this horrific event got her home address off the internet, her family names. He was a disgruntled person, and went to her house that based on information that he just simply gleaned off of the internet. I spent 14 years as the county prosecutor in Bergen County. It had its downsides, and every once in a while I would be the subject of a threat. I actually was the subject of many threats, but my chief would usually review them and determine which ones they felt were credible. And there were a few that were. So I was blessed to live in a town with a great local police department. They would park a police vehicle out in front of my house 24/7. I had pole cameras set up around my house. There was an action plan at my kids' school that if something ever happened, they would know where the kids were in school at any moment in time. So I know what it is to be a covered person. I know the fear that many judges, prosecutors, investigators, retired judges, prosecutors, investigators really face every day. The law's purpose is not denied by anyone. No one on this forum, no one in the public, everyone understands its need. But the problem is these 2023 changes have effectively rendered the current statute inoperable, meaning it really no longer protects me. There are people that are benefiting by it, but not covered persons. And that probably is the most significant thing that the 2023 amendments, I'll talk later about specifically who is really benefiting now, but the law today is broken and it really needs to be changed again.
Thank you, John. Kelly, do you mind just maybe elaborating on the 2023 amendments and the impact of business?
Sure. And thank you both for being here with me today and for all those that are tuning in. And, I share the sentiment of the importance of this law. And, I think today our focus is really talking about how these amendments kind of distracted from that law. So you heard John and Tony talk about the horrible tragedy that happened here and that the law was intended to protect cover people from the kind of public disclosure on the internet that led to these horrible acts. And so there were really four key changes to the amendments of Daniel's Law that kind of diverted the law from its original intent or efficacy, and really has an impact on businesses everywhere throughout the country, and especially in New Jersey, just because of the type of business you do and the people that you probably interact with. So this is not a data broker law. The law does not apply just to folks that publish things on the internet. The law applies to any person or company, anyone. So it applies to individuals as well. So going into the amendments, there are really 4 areas that that were changed through the amendment process. Now, originally, the intention of amending Daniel's Law, I believe, was to add another category of covered persons. So there's Daniel's Law on the federal level, and that really speaks to judges and their families. And then the state level, I think we've done something extraordinary where we've expanded the scope of covered persons to include other public servants, which is why John Molinelli is a covered person, corrections officers, their spouses, their immediate family members, and I think that's a wonderful thing. And while these amendments were coming on to add additional categories of people that serve our state, some other things snuck in. So I'm going to talk about 4 specific areas that were amended that really impact probably everybody on this call and everybody listening. So number 1, there was a change to the requirement for a verification. So under Daniel's Law, and I'm going to share a screen to show everybody, this is the actual amended law. And so some people have never seen an amended version of the law. It's kind of like nobody wants to see how the sausage is made. But this is very interesting because you can see exactly kind of what happened here. So I hope everybody can see my screen. Can you all see that? Okay.
Yeah.
So if you see here, this first section, the part that is redlined is what was taken out. So this is the verification requirement. So under Daniel's Law, there's a slightly different standard for private entities where the government has a different standard, but this is for private entities and private people. So you have 10 days to act on a request to not disclose or redisclose. And it says here on the internet or otherwise make available the home address or unpublished phone number of any covered person, which is fine. But then here you see they took out the requirement for the Office of Information Privacy to approve a redaction or non-disclosure of the individual covered person's address. That requirement of the Office of Information Privacy is still in effect for governments, but this means for businesses that you don't have to go through a process of proving that the information that you're asking to be redacted is actually redactable under this law, or having someone confirmed that you qualify as a covered person. So essentially anyone can send a request without that second verification from the state saying, yes, you are covered. Okay, and see in the blue here, just so people understand, this is part of what was being added, which was fine, adding child protective investigators and folks like that as covered persons. The next kind of concerning change here was here in the section where you talk about damages for violating the law. And you'll see that the legislature changed this permissive, the court may award, to the court shall award damages. And it's actual damages of not less than $1,000 and other penalties. But that change there has been the subject of debate in a lot of litigation now. It seems to make damages mandatory. And now there's some constitutional challenges, whether or not just receiving a request and, you know, maybe not getting to comply in 10 days, whether or not you are automatically liable for $1,000 per violation. So this change here has caused a lot of concern and quite a bit of potential liability for all businesses, which was then impacted further by this third change. And this is the adding of an assignee. Now, Daniel's Law is very, very different in New Jersey at the state level than federal or any other state law equivalent, because there are laws like this all over the country that are intended to protect public servants. New Jersey, unlike anywhere else, added this assignee provision, which means if I'm a covered person, I send a request to someone to redact my home address and unpublished phone number. They fail to do so within 10 days. Now I can assign my right to receive damages under Daniel's law to a third party. So the implications of this for the businesses have been huge. And we'll talk a little bit more about how these changes are impacting hundreds of businesses throughout the state and throughout the country. And then the final change, and one of the most curious ones to me, was the change in the definition of what it means to disclose. I'm sorry, I'm scrolling very fast, but here it is. So disclose, and this is super, super important. When we were talking about Daniel's Law in the beginning and the purpose, we were saying, okay, this horrible thing happened where a bad actor went on the internet and found the home address for Judge Salas and her family and used that information to track her down, to attack her, to murder her son, and it was horrible. So we don't want people disclosing public servants' home address on the internet anymore, right? Because this is a horrible thing. Here, disclose does not mean publish publicly, and it does not mean put something out on the internet. This is why it applies to every single person. Anyone can get a request to not disclose, which means to not solicit, sell, manufacture, give, provide, lend, trade, mail, deliver, transfer, post, publish, distribute, circulate, disseminate, I know it's a lot, present, exhibit, advertise, or offer. And here's the part that has caused a lot of problems that was added. And shall include making available or viewable within a searchable list or database, regardless of whether a search of such list or database is actually performed. So that's confusing and it's a mouthful, and that's why I put it up so everybody can see the actual language. The point of this is disclose does not mean disclose as we would normally think of it. And so people that are finding themselves in litigation are saying, well, why does this apply to me? I'm not a people search company. I don't put anyone's information up on the internet. This has very drastically changed the scope of what's covered. And people have said, well, what does this mean? This database or list, whether it's searched or not, what do I do? How do I comply? What does that mean if I get a request? And, you know, how are companies supposed to respond to this? And so I will kind of flip it over because I know that was a lot and that was a mouthful, but those 4 areas were really the amendments that have caused a lot of confusion in the business community, a tremendous amount of litigation on every level of court in the state, up to, you know, the Third Circuit and the New Jersey Supreme Court.
That was excellent, Kelly. So since 2023, since these amendments went in, there has been litigation, right, around these amendments, and that's all ongoing right now, right?
Yes.
So I guess going back to you, John, is there anything you want to add to what Kelly said? And then I was going to ask you to talk about the coalition that you're part of.
Sure.
But yeah.
Everyone on this, I mean, other than maybe somebody on this form that might be a representative of government, I mean, this applies to everyone. The local landscaper has a customer list. They have to know where to go cut the grass. They have to have a cell number to call. Large corporations, every single business in New Jersey, this applies to. Everyone uses data. I don't think, you know, maybe there's some company out there that doesn't use data, but I couldn't think of one. I actually tried to think, well, who might not have data? And frankly, I can't think of anyone. We all rely on data. We use it. Our own customer list, our own contacts information, you know, law firms, all of us. I mean, we maintain data on who we serve. So the first iteration was not perfect. I acknowledge that. I think most people acknowledge that. There were gaps in having the covered persons be able to have contact with those people that had their data. Many covered persons don't know where their data is. So, it was not perfect, but at least there was a chance for businesses to verify who was asking. You get an email from a John Smith, please redact my information. Well, who is John Smith? Is he a covered person? Previously that was handled by the Office of Information Privacy. There's no longer any vehicle to do that, which requires a direct contact between the covered person and the company. And you're going to find in this forum that historically under the 2023 amendments, that has been wrought with problems. So these 200 or so lawsuits that have been brought clearly are a distraction. And what has really resulted by these amendments is that there are some investors in companies out there that are exercising assignee rights of covered persons that are really benefiting, and the people that are really not benefiting are the covered persons. The coalition was formed to further the voice of business here in New Jersey. Its intention is to restore the original purpose. Note I didn't say the original form. Even the coalition understands that the original form requires some changes, but they want to restore the original purpose. They want to bring back the law benefiting the covered person and not law firms or investors that stand to profit by this. They fully protect the need for privacy protection for all public servants. That's an important thing. If I felt that the coalition did not stand for that, if I felt that they were really working against the law, I wouldn't be here. I wouldn't be associated with them. It would be counterintuitive to argue for their cause if their cause was the complete removal of Daniel's law protections. So my concern now is that right now we have a law that really is not working for the covered persons, and the coalition stands for that. They didn't object to the original adoption of Daniel's law. Many of these companies, by the way, have been handling data this way well before the creation of Daniel's law. The larger companies, they understand the sensitivity and privacy needs to maintain this protection, not just for covered persons, but for their customer base in general. So I'm very pleased to be their spokesperson. I'm pleased to advocate for their cause because I think their cause is a good one and will really return the protection to all covered persons in New Jersey.
Oh, thank you, John. So I guess for both you and Kelly, let's try to drill down. And Kelly, when you read the definition of disclose, that was a mouthful. So possession versus disclosure. I could tell you after talking to a lot of our members, to your point, John, we all collect data, whether you're a landscaper or a mover, you're a big company, Fortune 500, everybody's got data, right? And everybody wants to do the right thing with the data. So can we just kind of focus in on possession, what that means, and legally versus disclosure?
Sure. So one of the things I just want to kind of highlight here for those that are not as in the weeds with this law as the rest of us. We talked before about the assignment in these amendments. 6 months after these amendments came into effect, almost hundreds, a little less than 200, hundreds of lawsuits were filed in various state courts throughout New Jersey against all types of businesses, small businesses, mom and pops, business to business only type businesses, real estate industry type businesses. Hundreds were sued by a company that had been assigned the rights of covered people. So that's why we care so much about the assignment, because it resulted in, I think there's 178 lawsuits now against even more companies claiming violations of Daniel's law on behalf of almost 20,000 people. And if it is a mandatory $1,000 per violation, depending on the amount of violations, you're looking at tens of millions of dollars in claimed damages against some companies that make, I don't know, maybe $100,000 a year. So the devastating effect of of these changes is already being felt by companies that don't even know what the law means yet. So that's a long way of going back to mere possession. The change that we talked about in the definition of disclose has this other piece that says disclose also includes making available or viewable within a searchable list or database the covered person's information, regardless of if it's searched or not. And so folks in the beginning of the lawsuit were saying, well, I don't publish anything on the internet or otherwise. I mail flyers for using the landscaper company, right? Maybe I mail flyers for a landscaper. This doesn't apply to me. And there were arguments initially in some of the cases by the plaintiffs or the company that has been assigned their rights, that even having a searchable list or database could be a violation of the law. Now, that was just kind of hard to swallow, because how does someone having an internal list similar to like a do not call list, to make sure you're complying, how would that in any way affect Daniel's law, right? How does my company having an internal list or mailing flyers have anything to do with protecting public servants? A bad guy's not going to get the address that way, you wouldn't think. And so these changes to the law have not yet been litigated. These cases have been going on for almost 2 years now. There's about 55 cases in the federal district court. There's a number of cases in the Third Circuit on appeal. There's over 140 cases in different counties throughout the state. In some places, judges have said that's ridiculous. This can't possibly mean having an internal use. And there seems to have been kind of a rollback to that initial argument of this possessing a list only would constitute a violation. But at the end of the day, we don't know yet. There has not been a firm ruling on it. The argument could very likely come up, and discovery hasn't even started. And so there are challenges about the constitutionality of the law as amended, and how do you interpret these changes to the law in a way that makes sense and gets back to the intent of Daniel's law.
Yeah, so I mean, I guess, Kelly, it's all evolving. It's very fluid. It's in the courts right now. But so what should businesses do at this point? I mean, question for you or John. I mean, with that information, I mean, to your point, right? There's no way, if I was to go through the list of my customers, is there a way to even know if they would be covered? Are they covered individuals? I mean, that would be difficult in itself, I would think.
Well, that's a good point. The loss of the verification process, the cessation of reliance upon the Office of Information Privacy. When the law was its first iteration, I went on the website. I went to the Department of Community Affairs website, Office of Information Privacy, and there is a registration page for me as a covered person to register. And I remember filling it out. I had to specifically set forth my term of office, who I worked for. I don't quite know how the Office of Information Privacy verifies it, but all you gotta do is check my pension records and you'll see it, But one thing that's odd, if I'm a business owner and I get this request or I become aware of this law, well, the first thing I'm going to do is, even if I get a demand from, say, 30 people, redact my name, I'm going to search my own database to see if those names come up. I'm going to compile a separate list. Okay, these are people that we need to make sure that we give them the added protection under Daniel's law. Well, guess what? I just created a list of covered persons. And I'm not going to create that list and just tear it up and throw it away. I'm going to maintain it somewhere. And it's going to have to be searchable. So if we get a demand that comes in, a person in my office perhaps that designated to search the records, it's a searchable record. It's something can be found. It's not on the internet, but under interpretations that Kelly has shared that are being thrown out there in the courts, we just don't know. So it's a very dangerous situation. I don't know. Well, I know what businesses can do to help change the law, but sitting right now, I'm an HR director, mid-sized company. I don't know what I can do. Other than if I do get a request to use my best efforts to try and verify, because if you get a name like Smith or Jones, a large company may have hundreds of Smiths and Jones on their database. So
Right.
how do we know this particular person is a covered person? Um,
So can I ask, John, why do we, or Kelly, why do we think the Office of Information Policy was taken out in the 2023 amendments? Because that seemed to be such a key office, right?
You know,
To
I don't
verify.
know. Yeah, I don't know why it was. It still exists. Their webpage still exists. There's a section where you can register as a covered person. There's a redaction section, and I'm not really sure what it is. Maybe funding issues. I don't know, but when its presence, when its ability to verify covered persons was removed, boy, that really sent a message that now it's up to the individual covered person to simply tell the company, I'm a covered person. But when you take away the ability of the company to verify who you are, it makes it almost impossible to comply, particularly when you get 20,000 of these demands served upon you in the week between Christmas and New
A
Year.
company can't call the office
No,
and ask.
yeah, I don't think they can. I think the original purpose was to connect companies with Office of Information Privacy, and I can't speak for the Department of Community Affairs. I'm not familiar with what's going on down there, but to my knowledge, I don't think the office has any particular connection to Daniels Law Enforcement today. I don't believe it does.
So is there a reference? Let me just bring up the federal do not call list. I know.
That's a good
We're
analogy.
familiar. Yeah.
Yeah, it's a good analogy. But that, if a company gets a series of removal requests, the only place for that company to go is to respond back to the requesting party, usually by email. And that's assuming the company got it. You throw a heavy duty dose of emails on a company, they've got their own internal security checkpoints that might be being picked up either as spam or, like in my office, it's held, um, and it's further examined, and then there's a message that goes out to the recipient saying, hey, we're holding things right now, you need to look at all of these. I don't know what I would do if I get a screen with 20,000 messages saying I need to look at every one to determine whether or not this is spam or not. I don't want to hit receive, because if I hit receive, I'm violating my own company's policy. I am not doing an independent inquiry to verify who this is from, what it's about. Um, the do not call list, we all remember that. Many of us wondered, was it really working? Because we would get the spam calls. And I'm hoping that doesn't happen with Daniels Law. There's got to be a vehicle reintroduced to the Daniels Law process where a covered person can independently verify their status and then connect that verification to the business world to give them an opportunity to see, even make it directly searchable. I don't know, I'm sure it could be done without disclosing the home address and personal phone numbers of the individuals. There's got to be a way to do it. We've got some great tech people in this state, and I'm sure we can do it.
Right. So I know we have 9:30, and this is for everybody on the call. If you have a question for Kelly or John, just put it in the chat and I'll read it. But we want to, again, keep going here with the conversation. So I'm going to pivot back to you, Kelly, in terms of the litigation, the ongoing litigation with some of these nearly 200 cases. Again, just is there any more context you could provide or things that, just raise awareness for our companies, as these court cases are going through?
Absolutely. And I think this ties into what do you do, right? If you're a company and you're hearing all this and how do I comply and what do I do? The first thing I would do is check your spam filters and check to see if you've received any of these non-disclosure requests and that you don't, or if they've been sent to you and haven't come through and you haven't received them yet. A number of defendants in lawsuits say that they never received a request and didn't even know about Daniels Law until they were served with a lawsuit. So the first thing I would do is check your internal systems, check your email, I know there was a case where Google was subpoenaed to see if things were put in junk, if they could be retrieved, if they were spammed. So check the settings on your computers and your spam filters and see if you have any requests. The other thing I want to say is that the assignment issue, right? So we said about 6 months after these amendments came in, all these lawsuits were filed, and they were filed on behalf of about 20,000 people. And so the complaints allege that during the holiday season, around Christmas, New Year's, 23 into 24, tens of thousands of emails were sent, the same email from the same email handle, to all types of businesses throughout the country, and I think some abroad, saying to not disclose my information. To the extent you are receiving requests, you only have 10 days to comply. So I would do best efforts to remove anything that is, potentially a covered person. I have a lot of companies that say to me, listen, I don't care if you're a covered person or not. If you don't want me mailing something to you, if you don't want marketing materials, I'll take your information down. So I would create systems the best that you can to remove, people's home address and unpublished phone number from any of your activities going on outside of your company. Internal compliance, again, we don't know what that is yet. Right now, the district court in New Jersey has said that there is a negligence requirement for liability here. And so that's currently the law that's being challenged in front of the Third Circuit. So what that means is where the change from the court may award damages was changed to the court shall award. Judge Bartle has said that there has to be something on the part of the company that was not a reasonable reaction, right? And so that you were negligent, you failed to act reasonably in response to the requests. We don't know if that law is going to stay that way or change. And that is part of the question that the Third Circuit now sent back to the New Jersey Supreme Court. So we're waiting for the Supreme Court to tell us on the constitutional challenges to the law as amended. This piece in particular, can all of these companies actually be held responsible $1,000 per violation just automatically, without anything further, without any bad intent or without any negligent or reckless intent? We don't know yet. So most important out of all of this, if you have lists of information, if you keep lists of phone numbers and addresses and you're not sure what to do, call an attorney. This is a very, very difficult law to comply with right now because of all the unknown questions. So definitely contact someone for guidance in compliance because it may be very different for you. But to be sure, again, this is not a law that applies to data brokers or people search companies. This law applies to everyone.
Yeah, so I guess, Kelly, can you just elaborate on a violation? What is it like if you have, when you say $1,000 per violation, is it, you have the information, is it per day? Is it per person? What nobody knows?
We don't know yet. That's
Okay.
one of the problems. So some people say, okay, I received this complaint, for example, and it's on behalf of 20,000 people. So if it's one violation claimed per person,
Okay.
$20 million, other people say, well, what if they sent, requests separately? Or if they sent requests for their phone number, their address, and those things were released 3 times. Is this now a $60 million liability?
Gotcha.
If I have
It's
an
all
internal database, is it
all
per day?
unknown
Is
at
it
this
per
point.
hour? Because it says regardless of whether a search is performed or not. So we don't know how the courts are going to say the violations will be calculated. We don't know.
So if a company receives a request, does that request include the individuals that they think, the information that they think you might have in your database? Will that
No.
third-party request say the following individuals are people that you are tracking or that you have information on, or no?
No, there's no requirement under the law, and there have been no allegations in any of the complaints that the companies that were sent these requests actually had any of the covered person's information to begin with. Um, so there's no requirement that you already have the information in the law. It seems counterintuitive because how do you redact something you don't have? So I would say if you don't have it, you don't have it. I don't know how you could possibly violate. It doesn't stop an influx potentially of demands, but you could, like a lot of these companies, find yourself in litigation spending hundreds of thousands of dollars on attorney's fees and really not even have gotten to the part on whether or not you have anyone's information or whether or not you violated or whether or not
And
you
wait, but that's happening right now, Kelly?
it's
That,
happening right
okay,
now.
that's
Yeah.
interesting. Doesn't
Yeah.
seem like it's not logical, right? You make it just doesn't seem that you don't have this information, but yet you got to defend yourself.
Right. And part of the problem here too is going back to something that John was saying in the very beginning, he is concerned about making Daniel's Law work for the covered person. And I think we all do. And one of the issues is that a lot of companies that are in litigation now, they say, well, I have an opt out on my website. You can go in, you can opt out, it'll automatically be processed. It doesn't matter if you're a covered person. Within 24 hours or 48 hours, your information is off the internet, it's off my database, whatever. The problem is that with this assignment of claims, those online or pre-existing opt-out processes seem to have been completely avoided. And emails were sent just to like your info at or your generic email in some cases. And so people who thought, well, I'm already complying with everything, I have these processes, it can't be me, find themselves in litigation nonetheless. And what that does to the covered person, if you're one of those 20,000 folks that were sent out in like a mass email over the holidays, if that request never got to the company, how could they have removed your information? Whereas if the individual or went through the process already established, their information would have been down. So one of the problems that we really struggle with is how do we fix this law so that there's not this delay? The law intends for compliance in 10 days. That's because, we want to protect people right away. So this delay that's being caused maybe, inadvertently through this assignment feature, I think is something that was an unintended consequence, right? I don't think the legislature ever thought that such delays would happen, but it is happening. And not only is it hurting the covered people, but also, it has the potential of bankrupting a lot of small companies just to defend. So it's a very difficult situation right now for folks.
Yeah, it seems like it's still a lot of ambiguity in terms of, and I'm going to stick with how do you know if you have a covered person? So let's talk about if somebody's status changes where a private attorney, and next month becomes a prosecutor, they become a covered person, and you may have that information. I mean, how do you deal with something like that?
Yeah, so I think that the covered person status is pretty easy to determine once you have enough information on the person. But I want companies to understand that you do not have to remove covered person's information until and if you get a request to do so. So you don't have an affirmative obligation right now to go check all of your records and see, do I have any covered persons in here? That's not what it is. The part that gets tricky is if you get a request from someone, I would say best practices would be just remove it just in case, because a covered person is not just a prosecutor or a judge. A covered person is an active, formerly active, retired judge, child protective investigator, a family member residing in the same household with these folks. It's a very expansive definition. So losing that verification piece in the law, it makes it very difficult to find out without, having direct interaction with someone, whether or not they actually qualify as a covered person.
I appreciate that. So, John, I'm going to pivot back to you to talk about the negative impact on businesses and individuals. Can you explain what Atlas is and what they've done? And then
Sure.
also, kind of related to that, is the role of PBA. We did see that recently there was a letter, an open letter to you from the PBA, and if you could just explain, how that has been interpreted.
Sure. Atlas was created by venture capitalists. They lobbied the New Jersey legislature back in 2023 for these changes that Kelly has gone through, many of which you can see create gaps. And I think those gaps may have been intended because it's those gaps that are now creating the ability to earn a profit off of this statute. They call themselves a data privacy firm, but they're not. They are single-handedly responsible for 175 of the lawsuits that Kelly spoke of. They have alleged claims against businesses in excess of 20,000 Daniel law violations. They take the position that a covered person can assign their right as a covered person to request non-disclosure. That's a legal issue. It's vague. If I'm a covered person and I request a company remove the privacy information and they don't do it. By the way, I want to note, for any company out there that is intentionally violating the Daniels law, then they should be hammered. They really need to really receive the force of the courts in terms of penalties. And that's why the judges should really be able to see the underlying facts surrounding these violations. I've been practicing law over 40 years, and I can tell you, judges do not like mandatory penalties. They don't like them. It takes complete discretion away from them. They almost feel that, well, don't you trust me? Shouldn't you be relying on my judgment, my ability to determine whether or not a violation has occurred, as opposed to just this checkbox, checkbox, checkbox. So, the right to take these claims obviously came as a result of their lobbying efforts with the PBA, the state PBA. I have to mention, I'm a big fan of the PBA. I worked with police and investigators all over the state, particularly in Bergen County, but all over the state for many years. A lot of them are friends of mine. And so I stand with them as a covered person to want the law enforced. I am with them. I would love to meet with them. I think I've reached out and I suggested maybe let's have a sit down. Let's collectively work on solutions that will bring about the original purpose and the original intent of Daniel's law. And really, they stand to benefit just as I do. Atlas, I believe, has taken advantage of a lot of these ambiguities, and a lot of these changes have created this incentive to litigate, this incentive to put a lot of money down. I mean, it's the threat to businesses is real. And by the way, the threats to non-covered persons as a result of these changes is you have to realize that suppose, my name is Jones and I have a relationship with a bank and another Jones submits a request to the bank, remove my privacy information. And under the Atlas scenario, 10 days is ticking, there's no verification, nothing happens. Well, what is a business to do? All right, it's now day 9. So what's that business going to do? They might go to every single Smith on their database and remove the address and remove the cell phone number. And now what impact will that have on the non-covered Mr. Smith when he makes a mortgage application and they're running a credit check through this company and all of a sudden they can't get their data released by the company because their name matched a covered person, and the only thing this company decided to do is delete all the information. I'm not suggesting that's what companies should do. I don't think they should really create a situation where a non-covered person would get injured, but this is just the incredible result that has occurred. So I did receive a letter from the PBA. I appreciated receiving it. I appreciated their interest in it. I think their letter was off base, though. I think they misunderstood my role on behalf of the coalition. I'm hopeful. I'm hopeful that the more police officers in the PBA start to see the negative consequences. I mean, I don't know what the arrangement is between the PBA and Atlas. That's a question that nearly needs to be posed to the union. But I got to believe there's a way where we all can achieve success with this. We can have a Daniels law that works, that covered persons can be verified, that their information can be protected. You know, I'm still not a fan of the assignment, but if that's going to be a line in the sand, there's got to be a way for them to have a private company protect their interests. But mandatory penalties, counsel fees, completely unnecessary. The reason for the initial law's ineffectiveness didn't really have anything to do with business. It had a lot to do with where the law maybe was not going as far as it needed to go. It was a fault of the initial legislation that it had its problems. Its purpose was great, but it had a couple of gaps connecting the covered person with businesses. So don't blame businesses. Don't change the law that says, if you don't respond to us in 10 days, we're going to hit you with a mandatory minimum, by the way. I would emphasize minimum $1,000 penalty. Doesn't mean it's going to be 1,000, but it's a minimum. You know, why penalize business? Why make it, and then in so doing, make it impossible for business to really conform with the law?
I appreciate that.
So that's my thought on that.
Yeah, no, that was perfect. I guess we have about 5-10 minutes left. A couple of questions I want to kind of tee up. Kelly, this is maybe for you. I know that the courts have yet to decide. I know it could take time. Any idea when the courts, that's my first question, is when do we think a decision will come down? But also a question for you and John. You know, I deal a lot with the legislature. Is this a solution to all of this better set in the legislature or leave it up to the courts? I mean, just share your thoughts on.
Well, in terms of the first piece of that question, I think that the answers are probably a couple years away if we go through the court system. On the state level, there are dozens of cases in a variety of counties throughout the state courts in New Jersey, in the different counties. Some cases have been stayed, some are in motion practice, and some are in discovery. Some cases are in the federal district court, and our answers are being filed this week. So while the Third Circuit is waiting on the Supreme Court, there are some things happening there. The Supreme Court has not yet accepted the question on certification. We think they will sometime this month. How soon they'll act, we're not sure. I think it'll be a number of months before we get a response from the Supreme Court. Likely won't go back to the Third Circuit, until next year for sure, after the new year. And then it may go back for further direction to the district court. So there are a lot of layers of action, and there could be additional appeals. So it may be a situation where the legislature is capable of addressing it more quickly than the courts. But really the timing, everyone wants to know how long is this going to take, because we have been going for, I guess it's almost 2 years now, and we're just filing answers. So it's been a lot of litigation for cases that are really not even in discovery yet.
Thank you, Kelly. John, any thoughts about a legislative fix versus?
I want to take this opportunity to really reach out to those that are attending this forum. And I want to thank you, Tony, and Commerce and Industry for putting this forum on. All of you out there listening, maybe not today, but maybe later on, business is the economic driver of our economy, and you have more influence than you give yourself credit for. I'm hopeful that anyone listening and anyone that might listen to this tomorrow or next week or a month from now, assemble, gather together, communicate with one another, and use your power of business to sit down, reach out to your legislators and say, I don't like this. I don't like the exposure it has to my business. That to me could be a powerful resource that goes far beyond what the coalition could do. The coalition is business, but If business collectively comes together and say, you know, we need to change this, it's not helping the covered person. It goes against Judge Salas's original idea and intent. I have not spoken with her, but I can imagine if she realized that right now the law is not, you know, everybody thinks the law is being enforced with these lawsuits. It's not. We have judges right now deciding whether to declare this statute unconstitutional. I don't want that as a covered person. I want to have a Daniels Law statute, but I want to have one that works. So with the help of your members, Tony, even your non-members in the business world, you have more power than you think. Speak up, assemble, collectively work with our legislators and the governor's office to make this necessary change, because until the change is made, I don't think we're going anywhere. We'll wait 3 or 4 years down the road. We'll have some judge decide what'll happen. Hopefully they don't decide that it's unconstitutional. Even the courts are asking each other's questions on how to deal with this. And if they're not sure how to interpret it, well, how could business interpret it? How could they do it? Speak up, business. Use your power, use your influence.
No, I appreciate that, John. I mean, I think the last hour has been fact that we've raised this awareness is important. I wonder how many of our companies actually are aware that this is an exposure that they could face, right? They have to check those requests, those emails, the spam boxes, clutter boxes, see if they're coming in. And to your point, John, I mean, just, is there a legislative fix that protects the intent of the law without exposing our businesses to these lawsuits, really, that comes at the end of the day. Again, I'm going to ask our attendees if you have any questions before we adjourn. Just put them in the chat box. If not, I guess Kelly and John, any closing comments? I mean, again, I appreciate both of you taking the time today to kind of raise the awareness and really educate us on, what this law is about. And anything you want to share?
Another reach out to the state PBA. We've worked together before on a lot of critical issues. Give me a call. Let's have a conversation. Hear me out. I'll hear you out. Let's find a solution.
Great. Kelly?
Yeah, I would just say, even if you think that this law doesn't apply to you or you don't have exposure, I would take a minute and, go back and look at your emails anyway. And if you have any doubt whatsoever that you may have received a request, not received a request, not sure how to comply with this law or other data protection laws, I strongly suggest that you reach out to your in-house counsel, reach out to an attorney, make sure a mistake in this space potentially could cost, tons of millions of dollars. So you can never be too safe with compliance.
Perfect. Well, thank you, Kelly and John. And I want to thank everybody for joining us today. We will send this out to the larger group probably on Friday. So yeah, we'll look forward to maybe having a second round here and continuing the discussion. So stay well, everybody. And we'll see you soon. Thank you.
Thank you.
Bye-bye.